This is a really fun event and a really fun panel, but I thought I would just take 1 minute and explain how we got to this event, this symposium. We had a case, a client who had been convicted of a homicide that he did not do. We were investigating the case, and he and we had been told for decades, better? Thank you, that there were no records for us to look to, no evidence for us to find. By pure happenstance, a student dropped a reference to some case he was working on, and we found out that, in fact, there were records in his case, which led to a monumental investigation by one of our attorneys that uncovered the evidence of innocence. While we were working on a petition to challenge that conviction, we were sharing that evidence with the district attorney's office that was responsible for the prosecution, and they were not interested. We kept at them. And weeks before we were ready to file our petition, our client died after 37 years in solitary confinement for a crime he didn't do, which led us to think there has got to be a better way. And can we not look at all the other ways that exist for us to do this kind of inquiry so that it does not take somebody 37 years and them dying in solitary before it becomes uncovered? And so one of the things we looked to was this wonderful grand experiment happening in North Carolina with the statewide North Carolina Innocence Commission. This is the only such commission in the country where they actually are a separate entity that has the authority to do what they're doing in investigating and recommending and overturning convictions. So we have many members that have been involved in that commission with us here today. We have Chris Fialco, who is a criminal defense attorney and represented a gentleman before the commission, and he will talk about his experience. We have Judge Arnold Jones, who is the current head of the North Carolina Innocence Commission and was a former judge, and before being elected judge was in private practice. We have Jamie Lau, who is currently a fellow at and a supervising attorney at the Center for Criminal Justice and Professional Responsibility at Duke Law School, and before that was a staff attorney at the Innocence Commission, so he can talk at it from a couple of viewpoints. We have C. Branson Vickery, who is currently in private practice, formerly an elected DA, and while he was a DA, served as a commissioner on the commission. And finally, we're very fortunate to have Greg Taylor, who was in 1993 convicted for a murder he didn't commit. After fighting for his conviction for 17 years, was ultimately the first person exonerated by the North Carolina Innocence Commission. And I'm going to just share a small story about Greg with you. Greg's father, unfortunately, passed yesterday, and he was offered the option of not coming because it would be so difficult. And his lawyer, Chris Muma, said that he told her, if I can keep one father from going through what my father went through, then this will be worth it. So thank you, Greg. So I'm going to start with some questions for Branson. And I want you to, I had sent a lot of these questions out ahead of time so that the panelists would have an opportunity to prepare their responses. I don't want to put them on the spot. And a lot of this is nuts and bolts. And so I'm hoping that you can describe for us the origin of the commission and its structure.
I could say that, you know, the origin is basically what Chris said, but that would be, I guess, woefully inadequate because a series of events occurred prior to the advent of the commission or even the study commission, and they occurred over a number of years, and you know, probably all the way back to 1995, I guess, is what I was aware of at the time of the things that were happening out there. I began prosecuting in 1984, and when I came in as a young, right out of law school, or freshly out of law school, I guess, I I felt like there were good guys and bad guys, and that by having a unanimous jury in every case and all the different protections that were out there, we just were not convicting innocent people. I recognize that we were probably letting a lot of people go that were actually guilty of things, but I just didn't see that as being a problem. And that was everything, and this may just be a function of age, but I think everything in my mind in those days was there were good guys and bad guys. Everything was either black or white. There were no grays. And maybe it's a function of getting older. Maybe it's a function of seeing a lot of things. Maybe it's a function of senility. I don't know. But, I mean, I see a lot of grays now. And I do think that the things that occurred when DNA, particularly forensic DNA, I'd heard about DNA. I took the biology classes in high school. I understood that there was this foundation building block of humanity that, or all living things that had DNA, but I didn't realize that there was an ability to use it in a forensic setting. The first case I became aware of a DNA exoneration was Ronald Cotton, and that goes all the way back to 1995. And I didn't know about it at the time until it was brought to my attention. And again, I was one of the DAs, I guess, at the time that were introduced to Chris Muma, who was working with who a lot of us thought an awful lot about, which was Chief Justice I. Beverly Lake. He was for lack of a better phrase, a prosecutor's judge, tough on crime. You know, that he was going to make sure that the bad guys went to prison like they were supposed to. Chris came to us with a proposal. I think the first time I had any introduction to Chris was through this program with Ronald Cotton and the lady who had identified him as being her rapist, Jennifer Thompson. Jennifer had been a student at Elon College, a little town in North Carolina. She was a very intelligent person when she was actually raped. She woke up in her bedroom being raped by this man. She knew that she was maybe not going to make it out alive, but she wanted to make sure whatever she could do, she would do to assure that whoever this was doing this to her would be tried. She looked at his face. She looked at the features of his face. She looked at where his head was in the height of the doorway as he walked out the door. She tried to do everything she could to make sure she got it right. One trial, she was a very strong witness, very convincing witness. The jury convicted the man that was charged, Ronald Cotton. Procedural errors led to another trial. This time they added on another victim of the same rapist that night. This time it was a double conviction, and it was strong evidence. In the 90s, as the forensic evidence came forward, forensic expansion, I guess you could say, ultimately some evidence came forward that was re-examined. The evidence came back that Ronald Cotton had not been the rapist. Somebody that he was in prison with had actually been the rapist, and the right things were done. He got out of prison quickly at that time. The very difficult process of notifying Jennifer that she had wrongly identified the person crushed her. She went through very difficult times. All this is recanted, by the way, in Picking Cotton. It's a book that Jennifer and Ronald Cotton wrote recently. And I guess when I heard her testimony, so to speak, about that opened my eyes to the fact that maybe we don't always get it right. And a series of other misidentifications came forward during that same time period. Again, Ronald's case, the exoneration was in 95. In 1997, an individual named Terrence Garner there was a wrongful ID there, and I knew about that because he was from the town that I was a prosecutor in. He had allegedly committed the crime in the nearby town. It was another Terrence that had actually committed the crime. That person confessed. We realized things weren't always the right results were not always getting done. In 2001, there was another individual, Leslie Jean. Then after that, it was Darrell Hunt. And my own personal experience later on with Dwayne Dale, I realized that we needed to look at things that when people claim they were innocent, we need to make sure that they had every benefit of looking into that. This serendipity situation that Chris referred to when she worked with Justice Lake, that was clearly where North Carolina was able to make the move. We're a very conservative state, I would think. Again, the DAs we all had our lips poked out when Chris came and spoke to us the first time. We just didn't think that was what needed to be done. Some of us a little bit more receptive to it than others. Chris, however, was armed with a guy that we thought the world of, that being Chief Justice Lake. He was interested in seeing this happen. He put together a Chief Justice's panel that led to the ultimately getting to the legislators. They met. Chris could tell this so much better than I do, but they had meetings where Justice Lake wanted to make sure it wasn't the law enforcement on one side and the goody guys on the other side, or whatever they want to look at. He made them sit at individual tables and have lunches together and to get to know each other outside their respective roles. There were a lot of fights that went on, but ultimately they got before the legislature, and they got the legislation went through that everybody seemed to, whether we all agreed on it or not, at least we could all live with it, and it made it through. But more important probably than the safety net that the commission created were some of the positive reforms that were made to try to fix things, like Chris said, on the front end. And some of those things that were so important, I think, were these sequential double-blind lineups that we never had done before. I think that was extremely important in making IDs proper. Recording of the statements of violent criminals, the preservation of biological evidence. And one of the things that I, as one of the DAs involved in all this, was really not opposed to at all was we always have Brady. Everywhere you go, if you ever go to one of these events, you'll hear the Brady violations come up time and time again. The big thing about Brady is it was on the DAs, or it is on the DAs in those jurisdictions that still adhere to that kind of a just minimal Brady discovery. It was on the DA to decide what was material to the defense. The defense doesn't tell the prosecution what's going on. The defense doesn't tell what their defense is before trial. So the DAs didn't know what might be material. I mean, there might be a few DAs that were hiding things intentionally, but generally we just didn't know what had to be. You know, if it was obvious that somebody else confessed, now that's one thing, but if it was a little bit more close to the line, we might not know what needs to be given up. So probably to me as a prosecutor, I could take all that out of the mix with the one change that now is required, and this prosecutors in North Carolina must give everything over to the defense. And I don't know that any other state is that strong. I'm not sure about California, what the rules are, but it's definitely not a Brady standard anymore in North Carolina. We got to give everything, and everything means everything. Now, we don't control the police. We don't have investigators in our office that actually investigate crimes, but we are the ones that take the investigations from law enforcement and decide whether or not to prefer felony charges to the grand jury. And if we find out we didn't get everything, then we can take certain actions, and the courts can take certain actions. And obviously, from a lawyer standpoint, we can go to the bar, have bar sanctions. More DAs in recent years have been taken before the bar, but judges can find contempt. They can obviously do the lesser remedies, which are continuing cases or dismissing cases, but they can also find anyone in contempt that doesn't abide by the law and put them in jail. I mean, that's not something that happens very often, but it's a possibility, and it's something that's there.
So I think
I've gone way beyond the question you asked, I'm sure there. But
I'm going to ask Judge Jones a few questions now. Judge Jones, I want to ask a little bit about the criteria and the screening for cases that come to the commission. What kind of criteria you use, what kinds of cases do those criteria screen out? if you think those are the appropriate criteria, any concerns that you're screening out claims of innocence, and who does the screening?
Okay. Good afternoon. First of all, the way I'll say this too, Linda. Our commission is 8 people. 2 are discretionary with the Chief Justice. The chairman is always an acting current Superior Court judge. That's me at the current time. We have a DA, criminal defense attorney, a victim advocate, a sheriff, and a public member who is not associated with law enforcement. So there are a lot of interests from different avenues on the commission.
Who appoints the commissioners?
Who are the commissioners?
Who appoints them?
Okay, they're appointed by the Chief Justice of our Supreme Court and by the Chief Judge of our Appellate Court. And every 3 years, there's a new appointment. I just started this pro bono job in January. It's quite time-consuming, but it's rewarding. As you are all here, you wouldn't be here if it wasn't. But to go through your question, first of all, it's got to be a complete claim of factual innocence. This is not constitutional-based. This is not Brady-based. This is, man, I'm innocent, okay? And that's where it starts, and that's where it ends. And it's not adversarial. It's a fact-finding mission, which is obviously so different from what I'm used to as I sit in court every week. But that's the first thing. It must be for a felony. It's not just limited to murder, as Brandy said. Rape cases, obviously. And I guess my first involvement indirectly with the Innocence Commission, I was a fairly new judge in 2009. And this gentleman, Dwayne Dale, had just been exonerated in late 2008. And I had the opportunity, I guess, to try the person who was actually convicted of that crime. And when I was trying the case, Greg Taylor came to court a few times. I'd never met Greg personally, and I didn't meet him personally then because I was trying the case. But trying that case got me interested in what's going on now, to be frank with you. But it has to be a felony. The person must still be living. No reason to go through this process if somebody's already dead. They must, again, claim complete factual innocence. In other words, if they were charged with robbing the bank, but all they did was they were accessory after the fact, well, they still, that's not complete innocence. Credible evidence of innocence must exist. Verifiable evidence must exist. The claim must not have been previously heard. We have what are called motions for appropriate relief in North Carolina, for example. It must not have been heard in a trial or a post-conviction hearing. This had to be, I'll call it new evidence or newly discovered evidence. And then the applicant, this is an interesting twist, the applicant has to sign an agreement saying, hey, you can have everything I got. Well, I'm turning everything over to you. And so the rules of evidence, I'll say, don't apply. Again, this is a fact-finding mission, and that's how we do it. Who screens the cases, Linda? We have a staff. The commissioners are appointed. These are not paying jobs. We have a staff at the Innocence Commission in Raleigh, and they investigate the cases. And it's interesting, the commission, I guess I have to sign off on it, but we have subpoena power, a lot of powers inherent in the commission, similar to what a court would have. And so we can go and get DNA done at the best facilities in America. And so we have that authority that otherwise did not exist before this statutory creation that Chris was instrumental in helping get started and Justice Lake began. So I hope I've answered your question.
Yes.
Okay.
Do all the applicants have counsel? And at what stage of the proceedings do they get counsel?
They can have counsel, but they at some point have to sign a waiver. And that's usually after some investigation has began. when it gets to the formal inquiry stage, they're required to sign a waiver, and at that point, counsel's present. Chris has been involved in that frequently. If we then proceed to hearing before the 8-member panel or before the 3-judge panel eventually, if you want to get into that, I will, but they have counsel then too. So I guess the critical stage still applies. What is a critical stage? Anytime they're saying we're going to agree to your rules, and anytime there are hearings before the 8-member panel or the 3-judge panel, then they have counsel.
One of the things you said is that you have the authority to get DNA testing done in cases,
Sure.
Which is fabulous. And you probably have access to materials that would allow that DNA testing to happen a lot faster than it would otherwise. Do the applicants have counsel when you do the DNA testing? Is that at the stage in the proceedings where they're entitled to counsel? That's
a slippery slope. It all depends on when the waiver is signed. At the waiver stage, that's when they have the counsel. That's an issue right now that we're talking about in our own. We have the ability to make our own rules too. It's kind of neat, isn't it? And there's been a group that's raised that. Chris, we're familiar with that. I mean, there's a group that says, we've got some concerns about this rule. But again, we're not adversarial. If you, I hate to say it this way, but if you want to use our ability to help, then you need to give us carte blanche ability to help. And we can't proceed to a formal inquiry unless we get this background DNA and other things done. And not everything is DNA, but it seems like a lot of it has been DNA. And I think eventually DNA testing will catch up with cases. And then I guess we'll have to come up with another theory under which we'll be working. But DNA has been a big part of it so far.
Judge Jones, how is the commission funded?
Scantily. That's another issue. We met not long ago and talked about what are our challenges. And our challenges are that. We've got Brandy touched on it, we've got a very conservative legislature, and I guess is California this way? Do you guys have a lot of extra money floating around? I don't know. We judges just got, and state employees just got this big, huge raise, a $750 bonus, which I'll take. But North Carolina, money's tight. And so we're constantly under budget concerns. We've got the staff constantly writing grants. I think we have 6 full-time employees, 2 are on grants, and those grants expire in December. So we've got 2 people who are hoping that those grants will be extended. So I think, to answer your question, Linda, that is a constant struggle. If I may be incorrect on this, but I think I'm right. I think our budget's $500,000 a year for all staff and in-house, and that's it. So we have to be, our executive director, which we're only been asked about 5 times a day, who's going to be our new executive
Jones,
director.
who's going to be your next executive director?
Yeah. To which I've given a very political answer. I'm optimistic. But our executive director has a lot of responsibilities, one of those being lobbyist. I don't know the way of saying it. That person, whoever we hire coming up, will have to be a very effective lobbyist to ensure the continued success of what we're doing.
I have one last question for you,
Sure.
Judge. What's the standard that you guys use, that you apply to determine whether or not somebody is actually innocent?
I think I may have answered that, but if I didn't, I'll try. The standard, again, is complete factual innocence. And if once we get to that, we go to the 8 members, which I'm part of. We have our hearing, and if we determine that it should continue, you have a flow chart, I think, in your red packets. It sets this out pretty good. But when we get to the formal inquiry and go through the commission hearing, then if the if we believe there is sufficient evidence of factual evidence, then we refer it to a three-judge panel. What happens then is, let's say the person was originally convicted in Wayne County, which is my county. I guess I'd be exempt now, but assuming I wasn't chairman, then the case would be referred back to me as the senior resident Superior Court judge. And 3 judges would be appointed to hear the final case. And the senior judge, that being the, not oldest, but the one with the most time on the bench, would be the chairman of that group, if you will. And the 3-judge panel then hears the case. And if they find by clear and convincing evidence that factual innocence has been proven, then the person is exonerated. And the claimant has the burden of proof in that case to show by the clear and convincing evidence standard. So it's a little stronger than beyond a reasonable doubt. But again, I think we've had 9 exonerated. I think only 1 has not been when it's gone to the final step. And Linda, there are hundreds, if not thousands of cases, I want to say thousands of cases, that are turned away. So this is not some we get 2 a week, 3 a week situation. There have been volumes of cases that have never made it to the 8-judge or 8-member panel. So
Thank you.
You're welcome. Thank you.
Chris, what's it like to represent somebody before the commission?
Well, I'm a kind of a pure criminal defense lawyer, and I can sum up what it's like, and it's bizarre. Because as Judge Jones was just recommending, when you get appointed to represent the fellow, he's already been through the commission essentially, and now you're essentially rented to represent him at the 3-judge trial. And it is a trial in a courtroom with 3 judges on the bench, so that's the first bizarre part. That's your fact finder. The second bizarre part is that you, as the criminal defense lawyer, have the burden of proof, which is much scarier than I thought it would be. And the third bizarre part is that, well, there's 4, I guess. The third one is that the standard is that you have to prove innocence by clear and convincing evidence, which is not something that, civil lawyers usually deal with preponderance. We criminal defense lawyers deal with beyond a reasonable doubt, and that may be somewhere in between there. And then the last part, which was mentioned, is there are no rules of evidence. And so you have 3 judges up there, and I'm putting on all of this evidence, and the prosecutor's fighting tooth and nail, and there are no objections. It's really bizarre. After the second day, Judge Spainhour had to just remind myself and the prosecutor, stop objecting. There are no rules of evidence. And then I didn't stop because I would say, Judge, that's hearsay, and I just want you to make sure you understand that it's hearsay.
In your case, your client had pled guilty to second-degree murder and was serving a 15-year sentence. How did the fact that he had pled guilty affect the process?
Well, I wasn't expecting it. That my client was a 20 when he was when the alleged event occurred. He was a 20-year-old, and he pled guilty 2 years later, after 4 of his co-defendants had pled guilty of a home invasion robbery, in which none of those 5 people ever entered the home or were anywhere near it. There were 3 real perpetrators that DNA found, well, that Jamie here found via DNA 10 years later. But it was a real hurdle for me. I went up to this county, which is in the mountains, a couple hours from Charlotte, and the DA and the sheriff were fearsome, I guess would be the word I would use, and feared by everyone in the county. And so when Jamie had already interviewed all the witnesses, but I went in to interview him again because I was going to put him on the witness stand, and they were all quite afraid of going on the witness stand because of the fearsome nature of the prosecutor. But also, they all said to me, "What do you mean? Your client pled guilty?" It was a real huge hurdle. Now, earlier in one of the other panels, I think Judge Cordell asked why people who are innocent plead guilty, and I think there's a one-word answer for that, which is power. in this county and other counties, there's just a huge imbalance of power by law enforcement and the prosecutors, and a huge feeling of powerlessness by especially young black men. And that is, so in any event, to answer your question, it was a hurdle that just infused every day of the case. I felt like I had to prove not only that my client was innocent, but that you shouldn't throw that out because he pled guilty.
From your perspective, how might the commission better address its mandate to find, identify, and overturn wrongful convictions?
Yeah, I'm afraid I'm not the person to ask for that because I really don't have a lot of involvement in the screening process and so forth. And so I think that's really the hardest job the commission must have, is because I do represent a lot of people who are in prison now, and they're all sending stuff, even if they're stone cold guilty, to the Innocence Commission because they've seen some exonerations.
I know you have a PowerPoint you wanted to use to demonstrate.
Oh, well, so yeah, one of the things you asked me was about discovery issues.
Yes.
So I brought a little show and tell about that. It's true that North Carolina, as Mr. Vickery was saying, has open file discovery. I think that started in 2001 or 2004. My case was in 2000. But open file discovery is only as good as what the police give to the prosecutors, but also we criminal defense lawyers are to blame for a lot of these wrongful convictions if we don't go look at all the discovery. So I had a little show and tell here. Let's see. All right. We'll get back to this part in a minute, but just gaze upon that for a moment. That was one of my favorite exhibits. We'll get to it. So what I did in this case, and one thing that I will note to you, is that criminal defense lawyers actually don't seem to have a great role in these prosecutor conviction review and other things like that. If we do follow our checklists, we can add our expertise to this. And one of them I had, this was a week before trial after Jamie had done an amazing investigation, and I had spent 60 days doing nothing but getting ready for this trial. But on my checklist was, go view all of the evidence, at the police station. Have them lay it out on the table. And they called me up and they said, there's a door that the murder occurred by shooting a shotgun through a door. And it's in this separate storage facility. Do you need it? Because we don't think it has anything to do with the DNA found on the bandanas that match the real prosecutor. And I just said, bring me the door, just because I always see everything. And I don't know if you can see, we went to see this, the prosecutor and I, and that's what came out. The door, and taped to the door is a notebook that says, Other Suspects Notebook. Other Suspects and Associates Bowman Homicide. And in that notebook was information about the 3 real perpetrators that the lead detective had never given to the prosecutors. It's still a mystery as to how this notebook got taped to the door, when it got taped to the door, and so forth.
Can I interrupt you, Chris? Because this
Yes.
was a learning experience for me. Because as Chris said, I had completed what was an amazing investigation by his account.
Yes.
However, I remember him calling and said, Jamie, did you ever look at the door? And I said, I'm sorry, Chris, I didn't, because I bought the line that we have this door, and it doesn't mean a whole lot. Do you want me to get it or not? And I had seen every piece of evidence in this case except for the door.
So, yes. And so, can I stand? Does this wireless? I know I might be going over time, but just give me one more minute. So, the other thing that I have to show you just this is that there was a video that was in this case, and it should start playing here. In the lower right of here is a gas station. The murder happened in a part of town where black people don't go very often, and the detective had gotten this video and put it into evidence, but none of the defense lawyers had ever gone to look at it, and this was a VHS tape.
Jonathan stood up, and that's why I feel bad now, because there's someone waiting.
and that had been taped over with a soap opera. This is a time-lapse video, and so that 4 seconds was about 11 minutes of time, and in that time, that car right there, which is the real perpetrator's car, had arrived. The real perpetrators had walked toward that camera, and that was erased from evidence. And so the real perpetrators, the defense lawyers had never gone to look at it or seen that, but clearly in that 11 minutes or whatever it was, they had walked. There were other witnesses who said they had walked in, and there would have been pretty good screenshots of those perpetrators, and my client, Mr. Wilcoxon, may never have spent 11 years in prison for something he didn't do.
Jamie, you're up. We're gonna have to. Oh, that's good. So, what did you now from outside of the commission and having been on the staff of the commission? What do you think are the advantages of this approach as opposed to other approaches, including maybe conviction review units?
So the Innocence Commission and its subpoena power is really, I consider it the best post-conviction review organization out there because it can access the materials that others, even I think even prosecutors' offices, because of their cognitive bias, are unable to find. The Innocence Commission, and it goes back to the checklist manifesto that we were talking about and Jeff mentioned earlier, it really has developed this method of finding evidence. And as Chris mentioned earlier, there's 20 cases in which law enforcement or a prosecutor's office has said the evidence is gone, it's nowhere to be found, we don't know what to do, we'd like to help you, but we just can't. And there's 20 cases where the Innocence Commission, just sort of going through its process, has located that evidence, and in 8 cases, it's resulted in an exoneration. So access is what separates the Innocence Commission and its subpoena power. And just to sort of highlight how important this is, Chris Muma had a case where, I mean, she turned over everything. It's a case of Willie Grimes looking for the evidence in the case, and everybody had given up on finding it. And then happenstance, somehow, the Innocence Commission got involved, and the police department found the fingerprints from the crime scene after, for how many years? 12 years, probably, denying the existence of this evidence. And once we were able to find that, it was ran through the AFIS database. The AFIS database came back to a career criminal with a 30-year history of assaulting women who happened to be their initial suspect in 1987. Had these fingerprints been located 12 years earlier, it would have saved society 12 years of that person committing future crimes. And had they used these prints that they had obtained from the original crime scene and compared them to their initial suspect, rather than rely on a bad eyewitness ID, they would have saved society 30 years of this person's scourge on society.
So what's the effect of an Innocence Commission inquiry on any legal options?
This is where, having come from the commission and now working on post-conviction claims as an attorney representing individuals who are claiming innocence, it's important. So the commission process does not impact on your ability to bring your motions in court. So if you go through the commission and they do not find that you've met the standard sufficient evidence of actual innocence for the case to go forward to the 3-judge panel, that doesn't in any way impact your ability to then go to court and file what's in North Carolina described as a motion for appropriate relief. So it really doesn't impact you if you have your case at the commission and then you want to go into court. Now, it may impact you if you wanted to go into federal court because of the statute of limitations in federal court. So that's a question of when, if that would be told as a result of the commission process. And given that the commission's new, I don't think that's a question that's answered. However, if you have a motion for appropriate relief prior to going to the commission, the commission's actually barred from considering evidence that was heard at that prior motion for appropriate relief at the commission process. So that creates somewhat of an incentive to go to the commission first, since it doesn't limit your ability to then go to court.
Have you found a problem with the procedural bar potential issue?
I don't think it's that much of a problem. I mean, the problem with the procedural bar is the commission actually assists with respect to the procedural bar, because in cases where there have been post-conviction motion after post-conviction motion, the commission statute says that the commission is barred from hearing evidence that has previously been considered at a hearing and ruled upon at a prior post-conviction hearing. So what ends up happening is you have inmates who claim they're innocent. They write these, courthouse or jailhouse lawyers write these motions for them, and they file those motions, and then they're filed in the court file. And then later, they're deemed procedurally barred from filing a post-conviction motion as a result of those motions that they had filed with their jailhouse lawyers. The way the commission statute is written and why it helps avoid the procedural bar problem is most those motions that are filed on behalf of individuals in prison by jailhouse lawyers, they never get a hearing, and they never have an evidentiary hearing. So those don't act as bars to the commission process. So the commission process can actually help you overcome what would otherwise be a claim barred in court.
Can you describe how the commission works collaboratively, if it does, with both defense counsel and former prosecutors? Should I repeat? Okay. Can you describe for us how the commission works collaboratively, if it does, with both the former prosecutors and defense counsel in its investigation?
So the commission, as I said, is the best post-conviction investigation agency that exists in the country from my standpoint. The commission is, however, an experiment, and it does, it can improve. I would say one of the great places the commission can improve is in its working with not only just defense attorneys, but in its working with the state as well, though I don't have as much experience in how the relationship is between the commission and the state other than my period of time there. I asked Chris on my walk over here this morning, I said, Chris, when I was investigating the case he was discussing, did you find that the commission was approachable when you came to the commission and you wanted to know what was going on in the case? And he said, yeah, before the commission voted to move the case forward, I could get updates on what was going on. I didn't get all the specific information, but at least I could call and get a broad, update on how the investigation was proceeding. Today, the commission has completely shut that avenue of communication down. It's changed since I was there. I don't know why they've made the change, but I can tell you, having had claimants whose cases are with the commission, just calling over there and asking what's going on. The answer is, our case investigations are confidential. I can't provide you with an update. If the status of the case changes, we'll let you know. Chris spoke to the problems with that. I mean, Chris has had cases there for 4 or 5 years. Chris Muma, I'm sorry, we have different Chris's and I keep switching between the two. But Chris Muma spoke about that problem earlier today. And the one thing I will say is I was happy to see the best practices for conviction review units included in the red folder today, because I actually brought that and printed it out because I think there's room for cooperation agreements or confidentiality agreements between the commission and claimant's counsel if the concern is that somehow communicating with the claimant's counsel is going to have a negative impact on the investigation because perhaps they run to the media or because facts of the investigation are disclosed. If that's really the commission's concern and that's why it's turned inward and stopped the communication, there's ways around it, and we should all get together and improve the commission because it is an experiment and figure out a way that those agreements can be entered so people have the knowledge to make informed decisions about the case.
Linda, can I speak to that?
Sure.
So here's what I think about why the North Carolina Innocence Inquiry Commission as being much more tight-lipped about pending investigations, and it's just my opinion, Judge Jones.
I've always heard there's more power in the listener than there is in the talker, so I'm going to listen. How about that?
There's more power in the black robe than in this blue blazer, too. But, and it's because, let me give you an example. Here's the reason, is because the commission is sometimes perceived as a prosecutor of prosecutors. And in my case, when I got Mr. Wilcoxon's case, I got a lot of people wanting me to go wholeheartedly after the prosecutor. And I made a decision not to do it for two reasons. One is because I didn't need to do it to prove my client's innocence. And two is because I didn't want people to rally around the prosecutor after I was attacking him. So I laid off the prosecutor entirely, except at one point I did perp ID him with a witness. I said, "Do you see the prosecutor in the audience?" And the prosecutor stood up, and I had a witness perp ID him, but that was fun. But you heard earlier panelists today saying that most, if not 90% of prosecutors or more are honest, hardworking people. And I think that the commission needs to be sensitive about making sure that things don't leak out in cases and impugn these prosecutors who have to get reelected in cases in which the commission eventually doesn't decide to go forward. I understand that. And I think, though, that these confidentiality agreements would be a good compromise there so that, so anyway, to sum up, I think the reason for it, Jamie, is the commission is being influenced by politics that prosecutors don't like being prosecuted.
So Jamie, I'm going to come back to you with a couple more questions. Because you were in the investigative and then on to the three-judge panel stage, you're very familiar with the standards that were applied. Do you think that the standard applied to refer a case to the three-judge panel is appropriate? And then what about the standard applied to determine innocence? Do you think that that's an appropriate standard?
I think they are appropriate. The standard for moving a case to the three-judge panel is whether there's sufficient evidence of actual innocence meriting further judicial review. So when a case is being presented to the commission, that's what they're trying to determine, whether there's sufficient evidence of innocence meriting further judicial review. There's at least one case I know that the commission was criticized for holding claimants to a higher standard than that. And I don't know what to say if they are holding cases to a higher standard than that, but you really want the commission to be sussing out those cases that are truly innocent individuals. So I think that standard is sufficient or appropriate, as well as its application in, for the most part, all of the cases that have gone through the commission. The three-judge panel standard is clear and convincing evidence of innocence, and I think that's an appropriate standard as well. I just want to make a comment about the three-judge panel. Being a witness on the stand testifying at a three-judge panel where there are no objections and fielding questions where you're just begging for one of the attorneys to stand up and make an objection, that was bizarre as well. And Chris will know some of the questions that he probably, I would appreciated an objection, but didn't happen.
Is there any opportunity to appeal or challenge a finding by the commission?
No, there's no appellate mechanism after the commission. If a commission does not find that the burden's met and it doesn't go to the three-judge panel, there is no appellate mechanism. But again, there is the possibility of going into court through the regular post-conviction process and filing a motion for appropriate relief. So that, in essence, could help you vindicate yourself as a result of the commission's work. And it should be noted that while the commission's really interested in evidence of factual innocence, very often it discovers evidence that wasn't previously known to the defense. So as a result of the commission's work, there is the possibility that a violation of Brady or some other constitutional procedural violation will be discovered that could then serve as the basis for a petition.
So if you're investigating a case for the commission and you uncover some evidence of Brady, what do you do? If you're not going to refer it to the three-judge panel because you don't have sufficient evidence of innocence, but you've uncovered this other troubling occurrence.
Yeah, so the commission statute speaks directly of that. The defendant is entitled to favorable evidence that's derived through the commission's investigation. The real question and where this gets a bit tricky is, perhaps it's a case where there hasn't been counsel appointed to the defendant. So what does it mean for the defendant to be entitled to favorable information? If they send a letter to the defendant notifying him that they're closing the case, however they found this evidence, they want him to know, is that defendant not having counsel positioned to take advantage of that information or to utilize that information in the post-conviction process. I don't think that that's something we have a good answer to. When I say good answer to, we don't know the number of times that may happen and if those individuals have had an opportunity to then find folks to take their claims up for them.
So I have one last question for you, Jamie. How common is it for the commission to deny a finding of innocence and then the applicant go on and obtain some relief in the courts?
I don't know of that having occurred. Yeah, I can't think of an example offhand, but I'm sure it's happened.
In my case, well, there were two of us two defendants went in our case and were exonerated. The other three were denied by the commission, and then their MARs are pending right now, and they may come soon, but so.
Well, those three had refused to go take all five before the commission to begin with, though. They were approached by the commission to bring them all at the same time, and the three of them elected not to bring them.
Interestingly, one is civil.
Correct.
So Greg,
Yes,
you were exonerated in 2010?
2010, yes.
Had you challenged your conviction in court before you went to the commission?
Well, ironically, tomorrow marks the 24-year anniversary of my arrest. And at that time, I had a career in telecommunications. I had a education, experience, and interest in technology, and there were no shades of gray, like Mr. Vickery says. I believed in the system. I believed that an innocent person could not be arrested. I believed that an innocent person could not be brought to trial. I believed that an innocent person could not be convicted, and I believed that an innocent person would not remain convicted on appeal. I fought my case through the North Carolina Supreme Court. I fought it through state appropriate relief and up through habeas corpus, and I fought it to the U.S. Supreme Court. In 2003, I was denied DNA testing by Wake County Superior Court, and that ended my legal battle through the courts. With all my appeals exhausted and no other way to get back into court, it was only then that I had to realize that I would probably die in prison. And a couple of years later, the Innocence Commission was founded, and now I sit here today in between prosecutors and defense attorneys, and I would like to referee that soccer match that you guys were talking about.
So obviously the courts didn't provide you any relief. How long did it take before you were able to get in front of the commission?
I applied to the commission in 2005. Well, I'm sorry, I applied to the North Carolina Center on Actual Innocence in 2005, and my case was referred to the commission in 2007. The commission had my case for 2 years, and in September of 2009 was brought in front of the 8-member panel, and then in February of 2010 was brought in front of the 3-judge panel.
So did you have to experience all that questioning with no objections as well?
I did, and you know, the one thing that I thought about that whole process was that I didn't believe you could get 3 judges to agree on what to have for lunch, much less a verdict. And but I've really felt that I had a strong case that was clear to anybody, you know, without a stake, and that if nothing else, at the end of this process, the world would know that I was innocent, even if the verdict would not be according to that. But as it was, there were 3 judges with unbiased and great legal minds and good hearts that heard the evidence in its totality, heard everything that the prosecution could possibly rebut that evidence with, including some evidence that the prosecution didn't even deem credible at my original trial they presented. So they pretty much threw the kitchen sink at me. And those 3 judges ruled that I was innocent, proving with clear and convincing evidence.
So you certainly had a much better experience with the commission than you did in court.
I did, and one thing about that, you know, from an extreme layman, I'm only an expert in my own case and how it went through the system. But the inquisitorial part of it, you know, kind of spoke to me more clearly than adversarial would, and that, you know, I had the truth on my side, and that I knew if anybody would seek the truth, and they would see the truth.
Thank you. I think we have time for questions now.
Let me just say one thing about
Please.
Greg's case. Greg's case kind of shined a light into some dark corners that hadn't been exposed, I think, before, and one of which was the problems that were going on with the SBI crime lab, and I think that's what one of the things he's referring to. Our state doesn't examine evidence forensically on a county by county basis. Generally, it's about a central State Bureau of Investigation crime lab, and had that case not gone to the 3-judge panel and been gone over with a microscope by Chris and Joe Cheshire and Brad Bannon and the team that was working on that I don't think some of those things would have ever fully come to light. So that was a positive result too.
So one thing we haven't talked at all about is compensation for people who have been exonerated. Is there any opportunity for automatic compensation for somebody who the commission has exonerated?
North Carolina General Statute 148-82, 83, and 84 address that issue. And yeah, we're now up to, you get $50,000 a year for every year you spend in prison, with a cap at $750,000. That's, I guess, an automatic if it goes through the commission. If it's done by the court, which more and more DAs are rolling over, I guess you could say, when they find that. I mean, we, believe it or not, we really do not want innocent people in prison. And when we find out to our satisfaction, we agree, we're glad to go before the court and cut these things, cut the years off it might take to go further. But then it has to go before the governor, and the governor has to give a pardon of innocence to get that money then. But now the money was a whole lot less back in '95 with Ronald Cotton. I mean, he hardly scratched at first, and then ultimately got about $100,000, I think.
So how long typically does a case stay before the commission before there's a resolution?
That's.
I mean, I can say it varies really substantially. If there was a case and it came to your desk and it seemed pretty apparent from the outset that, let's take the single perpetrator sexual assault case. It seemed pretty clear from the outset if you could find the victim's underwear and if there was biological evidence in the victim's underwear, and if you can determine whether or not it matched the individual serving time for the crime or not. In a case of that nature, after the DNA testing, it would move rapidly through the commission's process. Rapidly meaning the commission would prioritize the case, assign investigators, do what needed to be done for the investigation, and likely as soon as the 8 members could all get together to convene. I'm sure Judge Jones is learning the logistics of 8 very distinguished members of the state of North Carolina, bringing
8
them all
type
together.
A personalities.
Yeah, it can be difficult, but those cases can move rather quickly, and then there's other cases that move slowly because just their size, complexities, and the scope of the investigation is huge, and it's a small staff, so it takes a long time.
Does the yeah, please.
I can add one thing about that, which is if the commission votes it out to the 3-judge panel, the 3 judges put a lot of pressure on hearing it quickly because, every day is a day that the person might be in. So I got my case, I got the evidence on June 30th, and we tried the case starting September 7th, and it was a 2-week trial. I mean, it was just faster than hell.
Linda,
Yes,
can I add this?
please.
A couple things I'm hearing. One thing I think before you ever get to this stage, I had a case in regular court recently where there was, during the trial, evidence mysteriously appeared. And this one just really got me. You're going to love this one. So the DA says to me, he says, Judge, why don't you just dismiss the case now without prejudice? I'm like, yeah, why don't I? I said, because, one reason is I run for re-election next year. And, I'm not going to have this come up and bite me. I said, here's what we're going to do. You either dismiss it without prejudice, or I'm going to dismiss it and I'm going to impose sanctions. Somebody's going to jail. I don't know if he thought it might be him, but it was going to be some. And I did say this. I said, and I know one thing. It's not going to be me. And so I think one thing that and I kind of bring this personality to the courtroom, but at any rate, I think that's one thing that we as trial judges have to do is, I think, at least been my experience, is take the bull by the horns and, put it on somebody else. So that's one thing. And I forgot the other thing. Oh, the other thing. And the statute says in North Carolina, we cannot hear a case without an executive director. That's why I've been asked, I think in part, when we're going to hire a new executive director. So once that process is finished and we do make a hire, then we can proceed. But the question was, how long will it take cases to be heard? I believe there is a case that's really close to being ready to be heard as soon as we finish our selection of a new executive director. So I think I don't know who it is. That's the thing. We don't know these cases until the commissioners don't, until they're ready to be heard. And that's probably good. Thank you.
Does the prosecution ever elect not to challenge a case before the commission?
Yes, several times. I think that's a minimal amount of just looking at the evidence, and I know Sam Curran recently did. And now one went all the way through the hearing, the one in Vickery, I guess, that went all the way through a full-blown, hard-ass DA and tough situation, and he was going to try the case and have it heard and stand up for it, and then he got convinced during the trial. His closing argument, he got stood up and said, I think Ms. Moon was right. He's not guilty. He's innocent. And that was the closing argument for the state in that case. They are bizarre hearings, as Chris said.
What do you think should be done differently, Branny?
Do what?
What do you think might be done differently in the commission to make it work more effectively?
Speed of disposition, obviously, an important thing, but a lot of it's a function of money. Like everyone's underfunded, obviously, but I don't know. I mean, you can't throw money at everything. I mean, there are efficiencies that need to be looked at, and I think that's why these kind of events are important. I mean, we need to look at ways to tweak what we have and work on that.
What did the North Carolina court system learn in the Gregory Taylor case, and have they changed anything as a consequence?
Yeah, like I said, everything changed with the SBI. I mean, they are one of the only agencies that's gotten a little bit more money recently from the legislature because of some of these things that were happening. And we had a lot of different issues. I mentioned those exonerations, but in the midst of all this going on when the legislation initially passed, the Duke lacrosse case developed during all of that. So that just compounded the public concern about the courts, the judicial system, I guess, or the law and order.
There was a backlog of DNA. There was sloppy work done on DNA. The SBI lab, there was doubt a lot of times. In fact, Brandy just retired. Brandy was my DA. How about that? But right before you left office, there was some issue with some DNA with the crime lab, 30, 40 cases. So that's a work in progress, but I think it's certainly getting better. But I went to a judges conference in June in Chapel Hill, and they talked about the length of time getting samples to testing samples. And in some cases, it's in the, not just in the 100-day, it's like in the year and a half, 2-year range. And so I'll send an order up to Raleigh. I need this stuff in 45 days, and I'll get a seething thing back. I don't know that we can do it. And I'll say, well, you better, or appear in my court. But that's been a huge problem, is DNA.
So here's what I think about what happened after Greg Taylor's case as a trial lawyer, is that the exposure of some of the junk science in that case just reinvigorated the standard of reasonable doubt throughout North Carolina. Jurors had read about it in that case, and they started paying attention. But probably more importantly, prosecutors and judges, it seemed to me, paid extra attention before letting forensic evidence in.
Can I add one thing too?
Absolutely.
The Forensic Science Act of North Carolina kind of clarified some of those issues that popped up with the lab. But aside from the judicial issues or the lab issues, there were Innocence Commission protocols that were changed because I was the first exoneree through that process. There were certain hurdles that I had to unnecessarily cross, like, for example, at that time the compensation was not automatic, and I had to get a pardon of innocence through the governor before I could receive compensation. So that was changed as a result of my exoneration.
Great. Well, thank you very much. I mean, this is, like I said, a grand experiment that we're all looking to follow to see what we can learn in our own states.
How many legislators are here? I'm serious. How many legislators are here?
Staffers.
Okay, I'm going to make a suggestion, because I've suggested this in North Carolina. Legislators, I know you're busy. I got 1 minute. You know, I'm like Jimmy Valvano. I came all the way from North Carolina. I'm going to take a few seconds, okay? All right. But I don't know if you guys are full-time legislators. Our guys are part-time legislators. But if you could take some time and go to your courts and see how people work in the court system. That's what I've encouraged our legislators to do. I've actually gone to the legislator to see how they work. Okay, it goes both ways. And I'm not saying everybody has their agenda, I know that. But I think it would be worthwhile to California if your legislators would go and see what happens in your courts. Most of the legislators in North Carolina haven't done that. Thank you.
All right, I thank you to Linda Starr, and thank you to North Carolina.